And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And Mr. May. And in cause number 24 DCCR 2431 with the offense of unauthorized use of a vehicle. Mr. Wilkerson has filed a motion just in the murder case, correct?
Correct.
That I reduce the bond.
Yes, Your Honor. Which I believe is set at 800, if I remember.
Let me pull it up so we make sure. Let's see.
Let's quote because I have had several of these.
It looks like in the motion it shows
Just the murder.
the murder is set at $800,000. And Mr. Wilkerson, do you intend to call your client or other witness?
Your Honor, I just intend to call my client and then also Venetia Jones if she is still present.
Mr. Johns, best you can, raise your right hand. Or Jones, I'm sorry. Do you swear or affirm the testimony you're going to?
We're stepping straight into a tense courtroom moment, a young defendant facing a murder charge while already entangled in other criminal cases. But here's the twist, he claims it's not what it looks like. Stick around, because this hearing reveals far more than just a bond request.
Given this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Thank you. You can go ahead, Mr. Wilkerson.
Ms. Jones, you are obviously the same John Jones charged in this case with murder. You also have a companion case in which you are charged in a separate offense with unauthorized use of a motor vehicle. Is that correct?
Yes, sir.
And how long have you been incarcerated?
About 3-4 months.
And during that time, has that time you had the murder charges pending during the entirety of that time? Is that correct?
Yes, sir.
Now, the person who actually pulled the trigger with regard to this offense has pled guilty and been sentenced. Is that correct?
Yes, sir.
And that was to 30 years. Is that correct?
Yes, sir.
And he was on parole at that time, correct?
Yes, sir.
And until previously, at least as of the 24th of July, you had been off of 35, correct?
Yes, sir.
All right. Now, during the time that you have been incarcerated, you have had some run-ins with staff with regard to some behavioral issues. And obviously, if the court is going to consider lowering your bond and how you would be able to behave or would behave in the community at large, were she to grant a reduction in your bond, there are some concerns. And so I would like to give you the opportunity to speak to those concerns, and I would encourage you to emphasize conditions that the court might be able to impose that you would be ready and willing to follow that might curb some of those concerns for the court while this case remains pending.
Yes, sir.
Go ahead.
Let me say, while the write-up thing was going on and going around, I didn't have my proper medications, but I was supposed to be seeing a psych nurse to take my proper medications. And I feel like if you was to give me a bond reduction, and I was to get those recommendations, and I was to make bond, I'd follow the rules because I take my medications now, which are for my anxiety, depression, and things of those nature. So I feel like a bond reduction is necessary, but you know.
So you have your medications now?
No, but I should have them by the 21st.
So I mean, anxiety and depression don't make you say things like
That exchange right there is crucial. The judge is testing his accountability, and every answer matters. In bond hearings, your past and present behavior speak louder than any lawyer's argument. Jones's credibility is hanging by a thread here.
I'm gonna sit here in front of you. I never said those things, but
You didn't say those things?
no.
You didn't ask her how could she have a boyfriend with how ugly she was?
Never said that.
You didn't ask how many boyfriends she ever had?
No.
You didn't say any of that. They're just making that up on you, just lying.
I have to.
Have to be lying. You didn't threaten just a couple weeks ago an officer that you were going to throw hot water if she didn't call somebody?
Yes, ma'am.
You did threaten to do that? Okay. Did you... Did you say at one point when y'all were getting in trouble that what it had to do with somebody giving a Bible back to another person, and you inserted yourself in something that wasn't about you, and you said, that's what's wrong with y'all officers. Y'all think we on y'all time, and I'm not. So you don't think you're on their time when you're in jail?
I never said that.
You didn't? They made that up too?
What I said was, respect is given both ways. That was my exact words.
Respect is given both ways. And so you think you deserve respect with how you're acting. I got pages of incident reports. And it's pages only starting in June. We're talking about pages over just the last 2 months. Fighting. You've been in at least 2 or 3 fights, right?
Yes, ma'am.
Yeah. Mr. Coleman?
Your Honor, I have just a couple questions. Mr. Jones, what did you do with the weapon after Lenny Nixon was shot?
I gave it back to Green.
And when did you and Green decide to rob Lenny Nixon?
Objection, Your Honor. These questions obviously go to the guilt innocence aspect of
I
this.
think you opened that door when you asked him about the shooting and who the shooter was. And the co-defendant.
When did the two of you decide to rob Lenny Nixon?
We never decided to rob him.
So if Green said you decided to rob him before he was shot, he would be lying?
I mean,
Yes or no? Yes or no, Mr. Jones?
yes.
Okay.
They'd be lying.
You knew the police were looking for you after Mr. Nixon had been shot, but nevertheless, you didn't turn yourself in, correct?
I didn't know. So
Okay.
after the fact, the next day.
When Lenny Nixon was murdered as part of this robbery scheme with you and Green, you were already under or on bail for UUMV, 2 cases of UUMV, and also a burglary of a habitation, correct?
No, sir. Never bailed out.
You were charged with those offenses, correct?
Yes, sir.
You
Regular
also-
accusations.
Right. You were also previously arrested for assault on a public servant, correct?
Yes, sir.
Criminal trespass,
Yes, sir.
another UUMV,
Yes, sir.
evading arrest, another evading arrest with a motor vehicle. That's all included in your criminal history, correct?
Yes, sir.
Who is Venetia Jones to you?
I'm
All right, pass witnesses.
Thank you. Go ahead, Mr. Wilkerson.
Yes, Your Honor, we've got to circle back over some of those. Just to be clear, Mr. Trevor, not Trevor, okay, Nixon was the gentleman who was shot, correct?
Yes, sir.
And you were staying at Nixon's house when Trevor Green came there, is that accurate?
Yes, sir.
And in fact, and Trevor Green initially told officers that you had discharged the weapon that had killed Nixon, correct?
Yes, sir.
However, even he corrected that statement ultimately and admitted that it was he who had the weapon, correct?
Yes, sir.
And on that evening, he took your phone, correct?
Yes, sir.
And he provided you the firearm that had belonged to Nixon, correct?
Yes, sir.
Now, you were asked about an agreement to rob Nixon of a firearm. And whether or not an agreement was ever reached. At what point, or at any point, and if so, how did you learn of Mr. Green's intent of removing or taking a firearm that had been in Nixon's possession?
It was about that morning, well, I'm gonna say around that night, 1, 2 o'clock.
What do you, and you say around that night, 1, 2 o'clock, what is it exactly that you were told at that time?
Nixon keep pointing the gun in our face. Let's just take it.
And how did you respond?
Leave me out of it. I don't want no parts.
And so, just very briefly, you yourself, Trevor Green and Nixon, had the three of you grown up together?
Yes, sir. We all went to the same school at one point in time.
Now, Trevor Green had just been released from prison, is that correct?
Yes, sir.
And is it the case that Trevor Green was actually coming into town to spend time with yourself and with Nixon? And Trevor Green, when he came into town, he was with his girlfriend, is that accurate? Okay.
Okay, we're not gonna try the whole case. I gave you some leeway, I gave him some leeway. I'm not gonna listen. I understand there's obviously some differences in opinion as to what happened and who's culpable. So that's all gonna be for a jury or for you guys to work out.
For just a couple more in a totally different direction, Your Honor?
Totally different direction.
All right. Now, you said you were getting your medications on the 21st. What medications are you speaking of?
I'm supposed to be taking trazodone, hydroxyzine, Verzocin, and they're supposed to be giving me another type of med for me hearing and seeing things.
So, while you have been incarcerated at Jefferson County Correctional Facility, the psychiatric or psychological staff provided by contract have made a determination that you actually have audio or visual hallucinations?
Yes, sir.
Okay. Your Honor, as a result of that, we will need to request...
Just file the appropriate motion.
Yes, Your Honor. I'll pass the witness.
I have no further questions, Judge.
All right. And you said you had another witness. Can you proffer what that witness would be testifying to for me?
Your Honor, that would just be his mother, Venetia Jones, and to the little bit of support that she would be able and really the inability to raise funds.
Thank you. Okay, thank you, and I'm glad she's here. Thank you. Where is she? Thank you for being here, ma'am. Okay, anything else?
Just a really brief argument.
Go ahead, sir.
Yeah, I filed it, I put that argument, I made clear in the state's reply to the defense counsel's motion to reduce the bond, so I'm not gonna belabor it. I just hit the high points, Judge. If the court is so inclined, the state constitution, the Texas Constitution allows you to hold this defendant without bond because he committed a felony while on bail for a felony, Judge. I've cited the case law, I've attached it to my reply.
I don't see that reply on this case.
It would have been filed on August the 6th of this year.
I see a couple of things. I see an order. Oh, never mind. It's right here.
Yeah.
Sorry.
I cite
Yeah.
Article 1, Section 11 of the Texas
Got it.
Constitution that states that if a defendant is on a felony, on bail for a felony and commits a subsequent felony, the court is well within its discretion to hold the defendant without bond if it so chooses to. And I've proffered to the court that I've spoken with the juvenile probation, with the juvenile department division of our office, and they have begun the process to certify this defendant as an adult, and that burglary of habitation is on its way, should be making its way to your court soon, Judge. We've got the criminal history that I think speaks for itself. Your Honor, we'd ask that this court deny the defense counsel's motion to reduce the defendant's bond. In fact, if the court is so inclined, we'd ask that you hold him with no bond.
Thank you, Mr. Coleman. Mr. Wilkerson, argument?
Your Honor, I think that if you look at all of the incidents that were mentioned by Mr. Coleman that are all juvenile incidents that have occurred with Mr. Jones, that it is quite clear in conjunction with some of the things that have also been mentioned, and also it fits into some of the write-ups that have been received as well, that Mr. Jones apparently does suffer some mental illness issues, and perhaps
And there it is, motion denied. The judge makes it crystal clear, actions have consequences. But should a 17-year-old with mental health struggles be held without leniency? Or is this exactly how justice should work? Let's talk about it in the comments.
maybe we should hold this in abeyance until we can have that properly addressed, in order to give the court some additional comfort that some of these behavioral issues might be more appropriately addressed.
Here's what I'm inclined to do at this time. I'm not going to hold the motion. We can always, if circumstances change, file a motion, and I will allow another hearing if there's a change of circumstances. Today, based on the nature of the offense, based on the amount of and nature of the incident reports from jail, based on the amount of and nature of the allegations of criminal history as a juvenile, Mr. Jones is 17, about to be 18, right?
Yes, ma'am.
So based on that, all of that, I am going to deny the motion to reduce the bond at this time. Obviously, it sounds like the jail is doing what they can to get Mr. Jones help. If you want to file a motion with regard to any other competency of whatever you want to file with regard to that, get that filed, and I'll take a look at it as soon as it comes through. All right, you go back with the bailiff. And listen, Mr. Jones, whatever issues you're having, none of that, in my opinion, coincides with how you're behaving, right? So you need to make an adjustment of what you're doing in jail. And if you don't, then Mr. Wilkerson's not going to have any argument whatsoever for me to reduce your bond later or anything like that. So I've probably talked to just about everybody in that dorm, I think, in the last couple weeks about this behavior. Y'all can all continue to act like you're acting, and y'all can all sit there and wait for your cases and then go to prison or whatever happens. Or somebody can step up and say, I'm not going to act like that. I'm going to get up when I'm supposed to. I'm going to follow the rules. I'm not going to fight. I'm not going to call names. I'm not going to, all those things. It's not that hard. Just follow the rules. You may not like them. Follow them. And if you can't, then stay in there and keep doing it. Does that make sense?
Yes, ma'am.
All right, go back with the bailiff. Sure. Sir, are you Larry Fletcher?
Yes, ma'am.
And so, Mr. Fletcher is on probation and cause number 21-37809 for the offense of possession of a controlled substance, a second-degree felony. That probation is from October of 2021. It was a 5-year deferred probation. And then it looks like we have two new offenses that have been indicted in cause number 25, DCCR 0838, an aggravated assault with a deadly weapon, and 25 DCCR 0839, a manslaughter charge. Mr. Wilkerson has filed a motion asking that I set a bond in the motion to revoke case.
Yes,
Is there,
Mr. Fletcher.
hold on, is there any motions in the other two, or we're just talking about the,
I believe the state filed a motion seeking to actually increase the defendant's bond.
in which
Your
case?
No, I filed in both cases. In the MQRP, we filed a reply to the defense counsel's motion to set a bond. And then in the other two cases, the state, the aggravated assault and the manslaughter case, the state has filed motions to increase those.
Let me get that all pulled up real quick and then we'll get started. Hold on. I'm printing, I needed to see all that. I just printed the response and,
Okay, I'm sorry, I thought I printed it all for you.
it's okay, we'll get it.
Sure, and waste some trees, man.
It's all your fault.
That's all my fault. It always is. In my mind,
I'm used to taking out.
in my mind, it's always my fault.
Are the PCs, I guess, would be the same in
For
the manslaughter and the ag assault? So I'm
Ag
just
assault, they
printing.
came out of the same transaction.
Okay.
Occurrence, Judge.
Give me just a second.
Yes.
Hold on. All right. So there's no bond currently set in the motion to revoke. The bonds in the two new cases have been set at $50,000 each. So I've got a motion to set a bond in the revocation, and I've got a motion from the state to increase the bond and or modify conditions in the two new offenses, correct?
Yes, sir.
Okay. With regard to the, well, I guess, Mr. Coleman, you mentioned that you would be willing to stipulate to some things before we get started with witness.
I suspect Mr. Wilkerson will call these witnesses to talk about the length of residency and the ties in the community, those kind of perfunctory things. If they will shorten this proceeding, I'm willing to stipulate to those if Mr. Wilkerson.
I mean, it to some degree, that is some of it, but obviously there are more intricacies involved, including the nature of the family, the length of work, things of that nature that I think all need to be put into play here.
And I don't mind hearing the evidence. I don't want to hear the same thing. They're here, and I appreciate they're here, and I'll take notice of that. But what I don't need is to hear from all of the witnesses the same thing about work and living and all that. So if you want to call one or two that have that information,
Absolutely.
that would be great.
Yes.
I just don't want it to be the same thing, and I'll take notice that they're here and that they would all say typically the same thing as if that's what it is.
Looks like he's on bond on two of those cases. I'm calling the bondsman right now.
Yes, he is.
He's already on bond. They filed a motion to increase the bond.
That's correct. So he, obviously this very tragic accident occurred one evening. There is no allegation of any substance use on the part of Mr. Fletcher contributing to the accident that involved the death of one of the victims and the severe injuries to the other. There is some, I guess the state's theory seems to be on the manslaughter, that he was reckless in his driving on that evening, thereby causing the death of another in the course of that reckless behavior while driving, which then makes it a stretch when the state then moves on to an aggravated assault charge for the second occupant of the vehicle, because of course if there were the intent and knowing element present there of course would have been a murder charge associated with the death of the first occupant of the vehicle. We are not debating obviously the tragedy of this incident, Your Honor. Mr. Fletcher on the night in question was actually responding to a work call. That is the reason that he was out on this particular evening. It was not after curfew, it was work related. He works for Ryder, the truck company, Judge. He's a mechanic. And as the court's aware, several years ago, Mr. Fleischer had an issue with substance abuse. Unfortunately, that's an issue that affects far too many people in the community, our loved ones, or sometimes ourselves, our family members, parents, sons, brothers, sisters, children. But Mr. Fleischer has been serving his probation faithfully. He has been supporting his defendants, Your Honor. He is engaged to be married. He has custody of his biological 2 children, and then also takes care of the 2 current children of his fiance, and is now welcoming a 3rd child. They are expecting that child. Mr. Fleischer has employment to return to, Your Honor, in terms of while these matters play out in the judicial system. Obviously, there are, the state seems to highlight Mr. Fletcher's driving record as a reason to change or deny bond in conjunction with the possession charge, which he is entitled to bond on. With regard to the driving record, I would simply say if that driving record, that, by the way, I have not seen certainly a certified copy of any driving record of Mr. Fleischer, but I have no reason to doubt Mr. Coleman's representations regarding that. There are certainly rules that the court could fashion. Obviously, Mr. Fleischer has a large family here supporting him, who have also been very supportive of the Thomas family since this tragedy. The allegation has to do in terms of Mr. Fletcher's fault in that death and that aggravated assault, which seems like a mighty jump in mens rea there. Your Honor, seems to be that he was traveling at such an excessive rate of speed on the night that when the person who disregarded the traffic safety device and entered a lane, failing to yield right away, Mr. Fleischer then did not have sufficient time to react and stop the vehicle because of his rate of speed. Obviously, we haven't had an opportunity to have our own investigators take a look at any of that evidence to be able to argue it at this point in the case, Judge. I only mention it so that the court is aware of the background context under which these allegations arise, and the sole issue at present right now in the defendant's or in the defense's opinion is whether or not to provide Mr. Fleischer a bond on the charge for which he was serving a deferred adjudication sentence and for which he has not been convicted, thereby, of course, making him eligible for bond in such case. Obviously, Judge, the law has changed in a number of ways, and if this were a case where Mr. Fleischer were some violent person, prone to violent outbursts, aggravated assaults, as the state alleges one of these was, although I I just don't understand how you.
I'm not gonna get into the legal, I mean, they filed what they filed, that'll be a question for later, so.
The issue here, Judge, is whether or not to grant him bail while the allegations that form the basis of revocation of this bond come to be addressed by the court. Your Honor, as I mentioned, and I would like to put his fiance on just briefly, his mother as well. And
Let me stop everybody. Here's what I'm inclined to do. I am inclined on the two new cases, the ag assault and the manslaughter, to in part grant Mr. Coleman's motion and modify the bond conditions. I don't believe I'm going to increase them because I think I can modify them in a way that will hopefully ensure the safety of the community. What I'm going to do in cause numbers 25 DCCR 0838 and 0839 is modify the bond conditions in those cases and order as a condition of bond that Mr. Fleischer is not allowed to drive, period, ever, any vehicle while these cases are pending. It does concern me, the prior allegations with regard to driving. We've got 2010 a crash, 2012 a crash, 2012 maximum speed limit issued, 2013 speeding over 10% over, 2016 speeding greater than 15 miles over, 2018 another crash, 2021 another crash, and here we are with a crash where I'm not going to get into fault, but there is a crash and we've got someone that has passed away and someone that is seriously injured. So that if I'm going to require that. I understand there may be work issues and that is what it is at this point. That is what I'm going to order in those two cases.
And I can understand that, Judge, but I would point out that the same issues of fault that belie this case, we're also uncertain of what.
It doesn't matter to me. We're going to stop having crashes no matter whose fault it is. When there's a common factor and there's the same thing that continues to happen, I can't help but at least have some concern that there is at least some type of fault on some of those. You know, you don't get into that many crashes without something happening. Okay, so my job is twofold: keep everybody else safe in the community and to do what's right with regard to you and your rights as well. But I've got to keep everybody safe, and based on that history at this point while the case is pending, unless something changes later with further order of the court, you are ordered not to drive. Okay. And so I think just by the nature of obviously that order, I'm probably inclined to grant the motion to set a bond in the probation case. And so I am at this time going to set the bond in cause number 21-37809. I'm going to grant the motion to set a bond. I'm going to set the bond in that case at, that's a possession. I'm going to set the bond in that case at $30,000. The condition of the bond is the same. You're not to drive any vehicle. And it doesn't look, I think Mr. Wilkerson is correct. I'm just looking at past administrative hearing that there hasn't been an issue with any type of positive drug screen or anything like that.
Not administratively, just but he is accused of, in addition to the manslaughter and the aggravated assault, accused of violating his probation with the possession of a marijuana case and also UCW.
So what I'm going to require is the condition of that bond on your MTRP case is that you wear a drug patch if you make that bond at all times. You'll have 24 hours from the time you're released to get a drug patch put on. You have to go change it every 2 weeks. On time, it needs to be on there, can't sweat off or whatever. You need to make sure it's on and it's testable every 2 weeks. Obviously, if there is a positive drug screen for anything in your system, it's a violation of all of your bonds, and you'll be right back into custody with Mr. Coleman probably telling me I told you so. So make sure you stay clean, make sure you do get it changed when you're supposed to, and all of that kind of stuff. So that bond condition is the same on all three of the cases. All the bond conditions are the same on all of the cases. No driving and drug patch on all three cases. Anything else?
Just procedurally, Judge, ordinarily, we would defer with these types of charges, new charges, we would defer the MTRP, we'll wait on that and proceed on the new case, particularly with how serious these are. However, in this case, I just want the court to know that we would be looking to go forward on the MTRP first.
Okay.
For a number of reasons. So we're looking to amend that MTRP. We'd ask that it be set prior to a disposition in the new manslaughter or aggravated
And you would be
assault.
intended on putting on evidence of those new offenses in that hearing? I would,
For punishment, the punishment part of it is, Judge.
I mean, to prove up the MTRP.
We have other things that prove up the MTRP, particularly the possession of marijuana, also the UCW, but there very well may be some additional testimony about those circumstances surrounding
So
aggravated assault and manslaughter.
there obviously appears to be some additional information, or maybe just because of the size of the cases, I haven't had an opportunity to review everything.
Yeah,
But
so-
there are some allegations that I'm hearing have not been at the forefront.
So let's do this. Obviously, you need some time to get all that information. If there's going to be an amendment, if you'll please take care of that quickly, make sure anything that's alleged in that Mr. Wilkerson gets any discovery with regard to any new offenses or alleged offenses that you intend to put. That way you guys can both have all the information. Mr. Wilkerson can do what he needs to with that information, and we'll set it for an announcement. And then we'll kind of go from that announcement on where to go next with regard to either the new cases first or the motion first. All right? Sound good?
That's fine.
All right, thank you. Y'all are excused. And thank y'all all for being here. I don't want anybody to think, I feel like we could cut it a little short and get that taken care of. All right, you go back with the bailiff.
Thank you.